Don't waste the summer months staring at a screen trying to figure out who accepts your vision insurance. Pearl Vision works with all major vision plans, including iMed. Plus, when you bring in the receipt from your last eye exam, they'll apply up to $150 towards a new pair of glasses. Visit pearlvision.com to find your neighborhood eye care center today. Valid prescription required. Valid at participating locations. Restrictions apply. Taxes extra. See store for details. Ends 10/31/2022. Exams available at the independent doctors of optometry at or next to Pearl Vision. Some doctors employed by Pearl Vision.
Welcome to Women Winning Divorce with your host, Heather Quick. Heather brings over 20 years of law experience that advocates and empowers women to achieve happier and healthier lives. Each week, we provide knowledge and guidance on different aspects of family law to help lead women through the difficult and emotional legal challenges that they are facing. Listen in as she discusses issues including divorce, custody, alimony, paternity, narcissism, mediation, and other family law issues to provide insight on the journey of women winning divorce. Welcome to the show. I'm Julie Morgan, and I'm joined by your host, Heather Quick.
Heather, it's good to see you again.
It is great to see you, Julie. How are you today?
I'm doing very well. Again, I was trying to figure out, what can bring some excitement to my life. And I saw this tennis outfit, and I thought about you. And I said, maybe I need to take up tennis. That'll help. I think so.
I wish you would. You know what I know? Julie, I know now exactly what's going to bring excitement to your life. I'm going to invite you to a spin class the next time we go.
Okay, Heather, wait a minute. You know what? This is not the topic, but we got to talk about spinning. Heather, I've tried that. So how do you sit on the little, I don't know, the little seat, Heather, the little
Well, most
seat.
of the time you're standing. Most of the time you're like standing and not sitting and just sweating. It's great. You'll love it.
Oh, my goodness. And Heather, wait a minute. Okay. But then when you do try to take a break and you sit on the little seat, you realize that it touches places you didn't know existed. And everyone that's listening, please, seriously, you know what I'm talking about when we're talking about spinning. But anyway, all right, Heather, enough of that. But you know what I'm talking about, don't you, Heather?
I do. This topic is not closed because we are going to add more excitement to your life, Miss Julie. You just wait.
But you know what? If you invite me, I will be there. I will, okay. And you're going to laugh at me the whole time. All righty. So today we're talking about the divorce timeline and managing expectations. How long does it take to get divorced?
Well, as you know, my favorite answer, it depends. But It depends on a lot of variables. And I think that for most individuals, the best expectation is they can just say, hey, this is probably going to take a year. Now, it could be less and it could be more, but I think that is a realistic way to say, whether you are like, oh, I don't like that answer, that's okay, but plan on about 12 months.
A whole year. Wait a minute. Okay, well, tell me this. What is the fastest? Have you seen it fast tracked and it's done in less time?
Oh, absolutely. And that's just by agreement of both parties. And sometimes it can be as short as 60 to 90 days. That is very unusual, but certainly for people who have agreed on everything and it's pretty simple. And, then if you have an attorney, then they can move it through the court system rather quickly. But again, that is all dependent on complete agreement.
Okay, that's what I was going to ask you. That's the key. You have to agree on 100% everything.
Yes, and it all has to be signed and done legally and properly. And, that there can be a lot of things. Some women are like, I'll sign anything. We probably won't represent you if you're going to sign something that's going to be detrimental to you, because we're not going to advise you to do that. Because sometimes, people are just ready to get out. And now, hey, if that works in your favor because your husband's like, I feel guilty, I'm ready to get out. It's like, well, that period of guilt is probably not going to last long. So you definitely want to have that paper signed, sooner rather than later. But overall, as we're going to talk about as we get into it, we will talk about the reasons, because we see on TV, it takes like an episode or two, but it really takes much longer than that.
Okay. Yeah, you know what? That's funny that you said that. I was going to say that. We see it on television and it's done in 60 minutes.
Well, I know. And Julie, just like Law and Order, which you know is my favorite show, I mean, it's only 60 minutes for the crime, the investigation, and the trial. And that just doesn't happen. So if you can say, oh, yeah, that would never, that they can't even get to the crime scene in an hour. And on TV, they've done the whole thing. So it's just, it does. It takes, there are reasons it takes time. Sometimes it takes longer than it should. But, you know, in order to fully, you know, have the information you need, that's why sometimes it takes more time. Because you need more information, and there are certain rules that allow for you know, if we need to see some bank statements, your husband has usually 30 days to provide them and 30 days to do something else. So everything kind of like the months add up rather quickly.
Okay, you know what? Let me ask you this. Is that part of is that the law that you have to give a person that much time in order to give you the information?
Yes. And that's, you know, those are the rules. There are different rules of procedure for different types of things. We'll kind of get into that a little bit later, but it helps to understand, like, you know, a lot of, just like when you're served, you know, you have 20 days to answer. So basically that, I mean, you only have 20 days. So I'm not saying you have 30 days, but there you go. 20 days, that's a month. Then maybe there's something else you have, maybe 45 days. Okay. A month and a half. So then things, even though to the person living it, I know it can seem to be going slow. However, there are reasons for those time periods within the law. So that's how it adds up. And then, you know, at the end of the day, if we need to get a hearing, well, it's not like the judge will say, okay, come in next Wednesday at 9 a.m. Basically, they're like, well, I have time on my calendar, you know, September 10th. At 9 a.m. for 30 minutes.
Wow.
Because there are a lot of people. Exactly. And so guess what? I may already be in a trial. You know, one of our other attorneys may not be able to do that date. So it goes to the next date. And, you know, I know that kind of gets in the weeds, but it's the reality of the litigation process that is not even anybody trying to delay. It is the reality of just, you know, scheduling and timing and how, you know, like what did we talk about in a previous show? You know, are really 50% of the people getting divorced that are married? Yes. And a lot of them are in the court system, which then create the court. The judges are busy. They are not sitting around wondering, you know, if somebody's going to need to come have their divorce heard. Their calendars are pretty packed.
Okay. And I know I kind of got ahead there, but I wanted to ask that question. Let's kind of double back. So if everyone agrees on everything, what type of divorce is that called? Does it have a name?
It does. And, you know, in Florida, it's called an uncontested divorce. And that means essentially that like everything is filed with an agreement at the same time. So even though that is usually, you will see that with people who are unrepresented and they just filled out the paperwork all together and put everything at one time. And that's just the term in the Florida procedure. And just because it's a contested divorce, that does not mean necessarily that this is a very adversarial. It's just, we file the documents and we might end up having an agreement, but we're not filing an agreement at the same time we're filing the divorce. Does that make sense?
Okay. I'm a bit confused. Okay. So uncontested, we agree on everything, but say that again?
We do. We agree on everything. And usually it's all filed with an agreement. Like you file for your divorce, and then maybe the two of you have either filled out the forms. There are forms that people can fill out online or print out and fill them out themselves. And that's where you'll see that term, uncontested divorce. And they're working through it all and they're doing it themselves because, and so then they kind of fill out everything, send it to the judge or the hearing officer. So that is usually the true definition.
Okay.
Go ahead.
I'm sorry.
I was just going to say that's the true definition, which really is a formality in the way the procedures are in the court. So if somebody's listening to this and they're like, well, I went to the clerk's office to do this myself, and they said, is this uncontested or contested? Well, that's where this comes from, because they're going to give you a stack of paperwork and tell you, well, this is what you guys need to do together. If it's contested, okay, we're not necessarily in agreement right now. Doesn't mean we can't come to an agreement. It's just we're filing for divorce, and now we are going to exchange financials, or maybe we're going to say, we're going to waive certain things. It's really a formality that I think people see more when they are representing themselves and filling it out. And they'll see uncontested divorce versus contested. And so they'll come to our office, I want an uncontested divorce. And that's great. And I know that everybody does, but it's not a unilateral decision, if that makes sense.
No, it does. Yeah, it does. So, you know what? I was about to ask you. I think I know your answer. Do you recommend not having a lawyer? I mean, I'm asking an attorney this, but I mean, is it ever okay not to have one?
I would say no, in the fact that you're entering a process that has its own language, its own rules, and you're not equipped to do it. It's kind of like when you enter the hospital, it's a different language, different schedules, procedures. You're not equipped. No matter what forms you read on how to stitch yourself up, you're not equipped to do that. But you can try. You can probably tape it up or whatever. Good luck with that. And similar to a legal proceeding. And with both of those things, you mess it up and you are stuck with the result. Most of the things cannot be undone. That's why, lawyers do train and do this for many years to help you navigate this process and make it really easier for you if you have somebody guiding you through.
That makes sense. That makes sense. Yeah. Okay. What is the petition for dissolution?
That is the initial paperwork that says, hey, I want a divorce. I am petitioning the court to dissolve my marriage. And so that I start that process by that document that really says these are the issues. In Florida, we are and this gets a little technical, but just to give an understanding, it's called, we plead, meaning that's how you talk to the court. I know on TV that the lawyers call the judges and we talk to the judges about cases, but that's not how it works. The way you speak to the judge is by what's written down and filed. And then they read that. They're not going to read a letter you send to just them. That's how it's done. And in Florida, we don't put all the gory details as to all of the things you want us to put that your husband did wrong, let's say, in this petition for dissolution. This is going to lay out the issues broadly because that is the way the law reads, and that's really what's appropriate. We're going to say, hey, this case involves alimony. This case involves child support. There are children, and this is who we think, this is how we are asking the court to, determine the time sharing of the children. These are the assets we have, and these are the liabilities. And then at the end of that petition, it says, Judge, we want you to award us alimony, attorney's fees, child support, pretty much everything in the kitchen sink is generally in that document. And I don't mean that to say they're all generic, just that if you don't ask for it, the law is clear. If it's not in there and asked for, the court can't grant that to you. So sometimes we have in there, hey, we want to sell the house. You have to have that in there. So if it's not done correctly the first time, sometimes, clients come to us, maybe they filed on their own, they had another attorney, and in that petition, it's not complete. It doesn't have everything that you really want to ask for, that we want the court to say, these are issues that need to be decided. So it's very important that it's outlined the right way.
Yeah, that is an important point because I didn't realize that you need to outline it before the first time in order to get it at the end.
And many times you amend it. But again, that's more, And that can be because things change, that you didn't think you wanted to sell the house, but in order to sell, you do have to have that in there. And so then you just have to file it again. That could be a reason for a delay because they're going to have time to answer it. So it's things that someone who doesn't do this, they wouldn't think of that, and nor should they, because that's not what they've been trained to do. So it's important. And many times when we get a new case and, I know we talked about this in one episode of trial and they're like, hey, my trial's next week. Well, this would be a problem in addition to a myriad of other things, Julie, but we would have to look at that petition. And if it doesn't have in there what is sufficient to be asked for you to go to trial, that trial, we're going to have to ask for it to be delayed so that we can make those amendments and changes.
Okay. Yeah, let's talk more about that. You're listening to Women Winning Divorce with Heather Quick, owner and attorney of Florida Women's Law Group. We'll take a break here, and when we return, we're going to talk more about this petition. Stay with us. Welcome back to Women Winning Divorce with Heather Quick, owner and attorney of Florida Women's Law Group. Heather, we were talking about the petition for dissolution. And you told me something that I definitely did not know. So, but let me ask you this. So after the petition, I guess, is filed with the court, well, let me ask you this. How long does that usually take, that process?
Of the filing of the petition?
Mm-hmm. Yeah.
Usually that will vary. And honestly, like some folks may say, hey, it could, take a month. It doesn't have to take that long. It really, again, depends on the issues and what, in your timeline, what we need. We would say usually like you hire us on the first of the month by, within 2 weeks, we should have all the information from you that we need. Many times, we are waiting on clients to give us the information that we have to put in documents that need to be filed. And so that can sometimes take longer because they are like, why do I have to give you all this information? But it's required in the law. So, maybe 2 to 4 weeks is completely reasonable. And obviously there can be cases where it's an emergency and that's just separate, not really what we're talking about here.
Okay. So after that, then comes the serving of the petition, right?
Yes. And so that's where most people have never heard that, you've been served. And that's our Constitution. You have it's your right to due process, to have formal notice. So anytime somebody is suing you, there's something going on in the court, that you have to receive that information in that formal way. So that's why it will be either a process server or a sheriff. And that really depends on the county. Some counties are like the sheriffs do all of the process serving. And, in other counties, you can have a private process server. So that is truly a formality to make sure that independent person says, I handed these papers to him, on July 15th at 8 p.m. That begins the clock ticking. So it's just an important part of due process of the law. But again, a procedure. We have a lot of procedures.
Okay. Well, do you try to, this has nothing to do with you. I guess after it gets to that point where it's the serving of the petition, because it could be kind of embarrassing for the person that's being served. Do you try to make sure that it's not, but again, this has nothing to do with you, but I'm going to ask it anyway. Do you try to make sure that they're not served in an embarrassing way? Like, okay, I show up to your job and then, there you go, you're served. Or you just, it at that point, it has nothing to do with you.
No, we absolutely, if it's a private process server, we have a little bit of control, and so, we're not trying to fan the flames or create, an embarrassing or difficult situation. And so sometimes the parties really are amicable. And so the process server will have the husband's cell phone and he'll be like, yeah, here, meet me here. I'll give you the papers. Or our client will say, hey, they, are always leaving the gym kind of around this time, so that they can just hand them to them. It's nothing adversarial. It's like, here you go. You've been served. It's not even that if the husband's been served, he doesn't have to sign for it. People are like, I'm not signing anything. That's not what it's about. You're just receiving it, handing it. So, right. It doesn't have to be. Now, when, like, for example, I'm pretty sure Clay County, the sheriff's office has to serve. We have no control. They're going to go to the house. They're going to go to the job at whatever time, at whenever. They're scheduled, where that process server, he's got however many to serve, and he's just going to serve them, the deputy from the sheriff's office. So then we cannot try to orchestrate that in a different way. But usually we do if we have that ability.
Okay. I was wondering about that because it seems like that could just create even bigger problems because they were embarrassed in a certain way, in front of certain people.
Yeah. And I mean, not everybody thinks about that. Our office does, many of our, and if like, hey, the kids are going to be there, we're like, well, we probably don't want to serve them as the kids are showing up. But,
right.
That's just something that I think is just the right way to do it. But I don't think very many other people think that way based on the majority of my clients just get served. So, but they may, I just think it's because, your client and you're not trying to, like I said, increase the animosity or, adversarial nature. That's not what we're trying to do. We just got to get them served. So.
Right. Okay. So after the person has been served, how long do they have to answer the petition?
In the state of Florida, they have 20 days. And that is 20 days from day one. You're served on a Saturday. You can't serve anybody on a Sunday. So Sundays don't count, but they count in the county. So you're served on a Saturday and we count 20 days. And after that 20 days, then, you could be what's called defaulted against. So those 20 days go pretty quickly.
It seems like the first few days may be just sitting there trying to understand, how did this happen?
Oh, probably so. Little shock, maybe denial, anger, all those great emotions that help us cope. Sometimes now they do know it's coming and they've already retained us. And so then you don't have to be served because we will accept service. That's what that's called. The attorney accepts service for the client. So that's a way to avoid that.
Okay, wait a minute. Okay. So the process server can bring the papers to you and not to your client.
That is correct. If they've retained us, you can't just say, hey, send it to this attorney. Unless you've retained them, they're not taking them. So I don't want anybody thinking, I'm just going to send them wherever. No, don't do that. But yes. And then that way, because generally there is I could look up on, our staff can look up on the docket and we can tell if something has been filed and you may not have been served yet. Or your husband may say, hey, go get an attorney, like we're getting a divorce, and then that attorney can get served. And that's because that's what they were told by their attorney, and it's true. And then we will take those papers on behalf of you and sign for them. So yes, it's a different way of getting served because then we receive them for you.
Okay. So would you suggest that if you did get the heads up, hey, you know what, we're done, go ahead and find an attorney then? Would you suggest that?
Oh, absolutely. Because that's kind of, this process we're talking about. That's what happens next. So yes.
And don't think about it. It's time to get the ball rolling. Well, I mean, you got to think about it, but don't wait too long.
Well, exactly. Ignoring it is not going to help.
Right.
That is not going to make it go away. And then you've lost some time. And then you start to feel pressure, just like anybody who's ever procrastinated anything. I certainly have. And then, of course, the day before it's like, oh, now I have to deal with this. I can't now I'm just put myself in a bind that creates more stress, anxiety, and all of that. So by putting that off, that is something you're really kind of doing to yourself.
Okay, so if I'm served, okay, can I serve in return? Kind of like tennis. Can I, well, I don't know, random thought. But can I serve him? If he serves me, can I serve him? Does that make sense?
You don't have to, because the lawsuit has been started and he is on notice because he initiated the process. And the reason you have to be served is so that there is documentation that you have been notified that this is going on. But now you've been served, you have your 20 days to answer, and that just gets everything in Florida now is electronic. So then it has to be filed electronically, your response, which is called the answer.
The answer. What is a counter petition?
Let's say your husband is filed for divorce. You're served with the petition that is, and his may not ask for alimony, may, want the kids, not the household. He has various things that are listed in there, may not have everything. Well, in order, now you can answer what he has asked the court for, but if you want alimony, if you want the household, if you want attorney's fees, you want anything out of this divorce, you need to file a counter petition with your answer, but you don't have to have that formally served. There is like a filing fee or something, but that process server only needs to happen at the very beginning of the case.
Got it. Okay. All right. So my counter petition does not need a process server to say, okay, well, this is her side now. That's where the lawyers come in after all that, right?
Yes.
Okay. Yeah. And that's how you communicate. Okay. What are mandatory disclosures and requirements?
So that is basically bank statements and your pay stubs, tax returns. These are the minimal things that are required when you file for a divorce to exchange with the other person. And I know, I can't remember which episode, but I know we talked about a financial affidavit and it's the budget. So these are a lot of things, that are required. There's a list. It's an extensive list, but not everything applies to everybody. And for example, it will say your last 3 years of tax returns, your last 3 months of bank statements, your mortgage statement, your tax returns. I think I just talked about that. If you have any other loan statements, if you have trust documents, some credit card statements. So basically, it says mandatory. This is like the minimum. This is the minimum that needs to be exchanged at the beginning of the divorce.
Okay. Yes, we did speak about financial affidavits, and you can go to our website, womenwinningdivorce.com, to download, subscribe, and listen to that episode. How long do I have to submit this financial affidavit?
The time period is each party after the initial filing is 45 days from the filing. So, and that, goes pretty quickly when you think of a lot of those documents. It can be, it's really not that bad if you just sit down and do it, but sometimes it's overwhelming to think, oh, I've got to get these tax returns, these bank statements. And, the financial affidavit is usually what takes most people the longest.
Okay. All righty. What is the discovery process?
So that's where each side has an opportunity to ask the other for more documentation. We really might want 3 years of bank statements. We might want information from your job. Usually we do if there's a corporate job so that we can understand the assets of the 401k. And sometimes we ask the other party for these things, and sometimes we send a subpoena because it's better to really get it directly from, say, American Express to really see, hey, what charges have been incurred, and then you can see what a lot of activity is. Or we want these business bank statements and we want the complete statements from the bank, because then that's part of the discovery, and that's when we are doing our due diligence and investigation to really ascertain all the assets and liabilities.
And this is also so the other party is not blindsided, right?
That is correct. And so, yes, you're entitled to you are really entitled to so much information. And that's the danger of doing this on yourself, because if you don't ask for it, you're not getting it. Nobody has to just voluntarily. I mean, mandatory disclosure, yes, but then if you go and don't make them give it to you and then go to trial and you don't know this stuff and you don't have it, I mean, the court is not going to say, oh gosh, we're so sorry, let's figure this out. No, you're on your own when you do this. You don't know what you don't know as far as what you would be entitled to ask for or how that impacts your case.
And how long does the discovery process take?
That's really what takes a lot of the longest time, because sometimes not everybody's as forthcoming or prompt in giving us the information that we've asked for. And so then there are delays. And then sometimes they say, well, I don't want to give you this. So we have to go to the court and have a hearing to tell the judge we're entitled to this information. We want this information. And that just takes longer. And so usually that's the whole process, because we want all of that to be complete in order to move to the mediation, because discovery we're discovering everything that's there. Then we can properly advise you and tell you, okay, based on the financial picture that we see, this is what we think, you're entitled to. This is how we think that assets and liabilities are going to play out. And this is, what that impact will be on you. And then we can then go to mediation.
Okay, that's a good segue into that. You're listening to Women Winning Divorce with Heather Quick, owner and attorney of Florida Women's Law Group. When we return, we're going to talk about mediation. Stay with us. You're listening to Women Winning Divorce with Heather Quick, owner and attorney of Florida Women's Law Group. Mediation. Heather, let's define mediation again. What is mediation and is it required?
Yes, mediation is required in all Florida divorce cases. And the majority of cases are settled in mediation. And what mediation is there is going to be it's not licensed, but a court appointed or agreed upon mediator, and they are certified. They are certified Florida mediator. Typically, they are going to focus on family law because it's not as helpful if could be a very skilled mediator, but if they're used to mediating personal injury cases, it may not be as effective. So you're going to go to a family law mediator. That person is independent, objective. You will go with your attorney. Your husband will go with his attorney. And at that time, they go back and forth and help each side essentially risk assess and do a risk benefit analysis and help each party get to a compromise that ends up in a signed agreement.
What if a mediator starts to take sides? I mean, does that even happen? That's what I think. I wonder, does that happen?
I'm sorry, does what happen?
Oh, I'm sorry. Does a mediator, can they or have they ever started to take sides? I mean, or are they just always in between, neutral? There are no sides. It just seems like as a human being, some of your humanness will take over. You know what I mean? I don't know.
Well, I think, of course, because they are human beings. We are not, we're not at a point where we've got robots through artificial intelligence doing the mediations, which could be very helpful. But maybe in the future. I think a really effective mediator, though, sometimes you think maybe they're on the other person's side. Now, I haven't had the benefit of going from room to room, but I think effective ones have that right personality disposition to build a rapport with your client, but say, well, can you see this from the other side? I'm not on his side. And frankly, I'm not on your side, but can you see it from this side? Because I'm trying to help him see it from your side. So I think it feels a lot, having been in mediations, done those for years. And that's why I hope for anybody listening to this understands that would be that is kind of a normal that you think that, because then that means they're really doing a good job. They're kind of not, somewhat playing the devil's advocate, but helping you see things from another point of view that then allow you to maybe come off your hard line as far as, no, I absolutely won't move on this issue, but maybe I'll do this. And that's just really a very skilled mediator who has those that ability to, one, build rapport with two opposing sides, and maybe, and usually not say maybe exactly what we're saying in our room, but convey the message. Kind of like on another episode, I know we talked about communication. Sometimes you have to communicate in a way that the information is actually heard. So I think very skilled mediators do that. And most of them in the beginning will tell the clients, listen, I know I'm not taking sides. You might think I am, but my job is to move each person a little bit closer to the middle.
Okay. I can see that.
And I think if they did take sides, they would not be effective, because you would know that innately. You'd be like, they are not on my side. They're not even trying. And I think that most, particularly in family law, because of so much emotions, the mediator, the really good ones, they know that, and they're working hard to say, hey, I'm impartial, but I'm going to present another way to look at something.
Okay. And as an attorney, if you see that a mediator is not doing that and they are being partial, would you step in and say, wait a minute, something isn't right?
Sometimes I'm sure I would, because the mediator goes back from room to room. And of course, at any time, if anybody wants to meet with them individually, they would. And mediation, it's required that you attend. It's not required that you agree. So if you just think they are off, then we're done. We impasse, we're out, we leave.
So it really does. You don't even have to start it. It doesn't have to be an issue. You could just say, you know what, we're not going to agree today. So let's move on.
Yeah, I think so. That's if we were really in that situation, that's what you do. If you think, hey, they are not even helping us advocate for where we're trying to get in this mediation, then it would be at an impasse.
Yeah. Okay. And when does mediation typically occur?
I typically don't see mediation occurring sooner than 6 months after filing, just because of scheduling and what we talked about in that last segment about discovery. And I think that sets realistic expectations.
Okay. Yeah.
It can be sooner, but I would say that's the exception, because you don't want to go to mediation without all the documents, or then how are you able to make an informed decision and settle the case? You should have all those things answered, not say, oh, okay, well, if we don't settle, then I'm going to do depositions. Now I'll take subpoenas, and now I'm going to do this and get experts. If you need those things, you do those things to prepare, and then you can make informed decisions and create a better settlement for a mediation.
Okay. Now let's talk about trial. What if we cannot reach an agreement in mediation? Then there's trial.
That is correct. And many times that will be set far in advance. But yes, you are going to have a trial set, and the judge then is going to be the one who's going to make the decision on the issues that, usually all the issues. And most, to get to a trial, that is probably going to be closer to 18 months after filing. And that's probably kind of close, because sometimes if it's really contentious in a trial, there's just other things going on. But, that's how long it takes to get there. And then sometimes we need a 1-day trial, some day 2 or 3 days, some days 5 or 6. Or some days, some cases, like where you say, hey, judge, I need 5 days. I've got 15 witnesses, and we know this is going to take a long time.
You said it could take 18 months just to get to that point. So really, it would be beneficial to try to settle this in mediation.
Absolutely. That's the reason that should be part of your cost benefit analysis. And cost can be financial, emotional, just overall, like, I want this done. And I think that should always play a part in considering what does that look like. Sometimes, and I know we've talked about this before, there's no settling and there's not even an offer that is reasonably close to what you would get even in your worst day of court. And so you're not going to settle for that. And there you're going to go to trial. And that just is what it is. And that's what you should do. And that's when your attorney can advise you, because you need to know where on the spectrum of this potential settlement is in regards to how things would be determined in court.
But would you say court should really, or a trial should really be the last resort? Let's try not to do that.
Well, that is not my perspective or point of view. I think because I think achieving your outcome is what we're going for. And sometimes that means a trial. So let's not treat it as if it's the worst thing in the whole world. That's why we have judges. And sometimes that's what we need to do, is get in front of a judge. So it's nothing to be afraid of. It is sometimes exactly what it takes. If there are other avenues, I'm all for that. I don't push all my clients like, no, we're not going to settle anything. We're going to trial, because that would not be wise at all. Every issues are different, but sometimes it's a case and there are personalities where don't say avoid trial at all costs, because you should go to trial. You'll do way better in front of a judge than dealing with the nonsense or lack of an offer on the other side.
So this is all case-by-case basis. It's all about that particular client that's sitting in your chair right at that moment.
And the issues. I would be cautious for anybody who has an attorney that doesn't want to go and who won't set a hearing and who won't go to trial and who is gun shy on litigating a case. If the circumstances call for it, that's why we have a court system. And it's nothing to be afraid of. And if your attorney has experienced one in family law, you are getting good advice, and you're going to know when there's an offer that is a good offer for you and makes sense or not, and when going to trial is what is in your best interest. Even though, hey, it may seem like, oh, this is going to cost more money. Well, it is, but not as much as the cost of maybe, accepting a terrible offer or, just walking away with nothing. So that's just my point of view, because I think that when that's needed, that's the whole purpose of the courts and the hearings. And some things just can't be resolved despite best efforts.
What is a final hearing?
So if you have a trial, eventually, that is the final hearing. That is when the judge takes testimony. So if we go to mediation and we've agreed upon everything, there are still certain questions that need to be answered under oath that the judge has to hear the answers to in order to sign off on the divorce. So, many of our clients will say, okay, we have a final hearing and we're going to now, in light of the new, that the courts have embraced the technology, when we used to have to all go down to court to do this 5-minute, essentially, procedure in front of the judge and sometimes wait an hour in order to have the 5 minutes. But now the courts allow most of this by Zoom, which is very beneficial for all clients, because this is a very procedural, but you do need to answer questions that prove you're a resident of Florida, that you acknowledge that the document, is what you've agreed to, that you had discovery, things of that nature. So that is the day you are actually divorced, because the judge will sign it on that day.
Okay. That's a final hearing. Okay. I feel like the last few minutes that we have should be spent talking about managing expectations. This can be a frustrating process. Am I right?
Absolutely. Anything that, I would say anything any of us do that we don't normally do can be frustrating. you're learning something new. You're having to go through something. You don't understand the process. It can be frustrating and difficult. So, I understand that. And it's a foreign language and all these rules and procedures that you've never heard of. So yeah, like, why do we have to take this long? And that is a very frequent question. And that's a fair question. And it's not always that there is a conspiracy by the court or your husband against you. It's just the circumstances of scheduling. And the more in my experience, the more information you have as to how long something's going to take, then at least, even if it's frustrating, at least you're aware and you're ready and you're like, okay, I know this is going to take a little bit longer. I know some of these things that happen aren't because my attorney's not doing a good job. My attorney has certain things that they have to on their schedule to help other clients, and the judge has things on their schedule, and so does my husband's attorney. And we all work to, move cases along efficiently. And that one of the most important things is communication with your attorney. And when you are given materials to help you understand the process, that you really review them. And when your attorney sends you stuff and says, hey, watch this video, read this pamphlet that I'm sending you because it explains what's coming next. If you will do that, then you will have a better understanding. And, the reason I called this Women Winning Divorce is because you can win at divorce. You absolutely can. And that is not meaning that your husband has to lose. You are just achieving your goals and outcomes. And I believe that. I very much believe that. And I think that's the way you approach it. Now, if you are approaching it, I just want him to lose, that probably is not going to be in your best interest overall, because you're not looking at it from a positive thing of where you want to be after this. And the more you communicate that, then the more we can help you feel as though you're achieving your goals. And to me, that's winning.
Heather, we are out of time, so we're going to have to leave it there, but it's always a pleasure.
Always a pleasure, Julie. Thank you so much. And as I usually say at the end of our show, for any woman listening, please reach out to us if you're going through any of these things and know that divorce is something that you're contemplating or it's already, knocking at your door. Reach out to us and let our team at Florida Women's Law Group help you through this.
And don't forget to go to womenwinningdivorce.com. Heather, I'll see you next week.
I look forward to it. Thank you, Julie.
Thank you for listening to Women Winning Divorce. We hope you found information to help you navigate your divorce. If you like our show, please take the time to subscribe and provide a 5-star review. If you need more information, please visit our website at womenwinningdivorce.com, where you will find previous episodes and other helpful content. Join us next week as we continue our journey of women winning divorce.
Switch to Metro by T-Mobile and save more. Get the new iPhone SE now with 5G at the lowest price in prepaid. Just $99.99.
I post a lot, and thanks to the iPhone SE with 5G and advanced 4K camera, I'm snapping and sharing while my followers are smashing the like button.
Switch and get the iPhone SE for just $99.99. Only at Metro. Save more versus national prepaid brands. Limited time offer. In-store only. Price for 64GB model with eligible port. $60 plan and ID. See 5G device coverage and access details at Metro by